Hey there, Daniel. How are you doing today?
I'm good. Good to see you, CJ.
Good to see you too. Hey, thanks for joining me on our Axiom Legal Tech podcast today. Really excited to have Daniel, CEO of DraftPilot, joining us today. I'm CJ Saretto. I'm the host of our Axiom Legal Tech podcast, and we're just here to talk a little bit about what's going on in the legal tech space, specifically around AI, and what better person to talk to today than Daniel over at DraftPilot. DraftPilot's a partner of Axiom's. We've been using DraftPilot for, going on a year now. Is that right, Daniel? And we've seen a lot of great results. But Daniel, maybe before we talk about DraftPilot, maybe tell us a little bit about you and your founder's journey and what you did before DraftPilot.
Sounds good. Yeah, before DraftPilot, I co-founded and ran a ALSP called Lexu for about 10 years. So we had a few twists and turns around the way, but where Lexu ended up was that we had a large team of basically former in-house lawyers who are doing bulk contract review and negotiation on behalf of our in-house legal clients. So it's how I got really familiar with what it's like to have to do contracts day in, day out. What makes it take so long, and we experimented with so many ways to try to speed it up because we were on fixed fees. Before that, even further distance past, I was a lawyer at a law firm.
You were a lawyer at a law firm, Daniel. What was that like?
I mean, I did it for 5.5 years. I didn't mind it, actually. I was doing large finance and M&A transactions, but ultimately I had this itch of wanting to create something. And I got the sense that within the law firm, they really liked it when you knew how a deal worked. And they basically said, you do that now. And I kept thinking, well, I want to figure out something new. Can you put me on something new? And at some point I thought that's what the job is. And even though I like the intellectual side of lawyering, I thought I owe it to myself to see if I can build something out there.
Okay, well, it's a big jump from M&A transactions to high volume commercial contract negotiation. What scratched the itch there, Daniel? Why'd you decide to go that way?
Well, me and my co-founder, Chris, who's our CTO, we started out not there. We started out building a marketplace for lawyers. So Lexu started out back in 2014 as kind of the Airbnb for lawyers. So if you were a business and you needed to find an attorney, we had this huge network of ex-big law lawyers that you could just get to quote on your job, see the reviews, comparison. And whilst everybody loved it, it was a really terrible business model. So everybody loved it, except perhaps our investors.
Okay, and how did you end up pivoting then to the world of large contract review teams?
Well, we found out that the most recurring jobs on that marketplace were actually corporates who had hired maybe 6 to 10 of our flexible lawyers to just do ongoing contract review for them. And that kind of surprised me. I had thought that that's something they would always want to keep in-house. So when we dug into that a little bit further, we thought, you know what, if we hire the lawyers internally and we can change perhaps how the work is done, we can do that a lot more efficiently. And I think we partially succeeded, but also we ran into lots of reasons why it's hard to make things more efficiently. And I think it's only now with AI that some of that's changing.
Right. So you and I have talked about this over time, right? Like this is a very deja vu moment in terms of Lexu versus Axiom definitely being competitors, having a lot of the same ideas over time. Obviously, Axiom is still very much a legal talent marketplace business, more tech enabled now than we were back in the day when Lexu was the tech enabled upstart. And both companies obviously created this what we often refer to affectionately as like business process outsourcing kind of process, where clients could take a lot of contract review type work that they wanted to playbook standardize and get out of their in-house operation and hand it over to us to make efficient and cost effective. That business is now spun out of Axiom called Factor, where we're out of that business. And it sounds like you're out of that business too, right? You exited from Lexu and started DraftPilot. So what made you decide DraftPilot was the next idea? How did you make this leap?
I think I was on record saying that I didn't think AI was going to change all that much, and that was a few years ago. So obviously, I'm eating those words a little bit. Those posts are still there on LinkedIn, but it was basically the technology catching up with what I'd always hoped would be possible. So at Lexu, I trialed a lot of these the AI solutions that were out there back then, and I just didn't find it actually made a meaningful difference in how many minutes our lawyers were spending on the work. And there were other factors that had a way bigger impact. For instance, like what positions are we taking? We would have one client pushing this kind of liability cap, another one having a much higher one, and that would literally blow out the negotiations. So it was more things like that that we were very focused on. It's only now, with how good the AI is today, that I thought, actually, maybe that has now materially changed. And now in our data, we're seeing that big change. So, what used to take us 2.5 hours as a red line might now take 20 minutes if the playbook's set up okay.
Wow. Okay. Let's talk about what actually changed in the AI, Daniel. Like you went from the skeptic to the guy leading a company that's trying to get AIs to cut out the work of lawyers, right? Especially on redlining. Now, we can talk a little bit maybe hypothetically or philosophically about what that means for the actual legal work that's getting done and what that means about the future of being a lawyer in this world. Is there something really simple that people could understand? Like, does it think? Is that the kicker? Like, what's the fundamental difference?
I think back then it was mostly machine learning based, and as a result, it was mostly flagging what's wrong. So you would send a contract out to the tool, and we would get back this 20-page report of everything that's wrong. But somebody would still have to then go through that report, first of all, and then grab the agreement and figure out where in the agreement to make the fix. And they would then have to draft the fix. So actually, when I timed that, and we were timing everything with like literal stopwatches, sitting behind lawyers, seeing different approaches, does it yield benefits? And there was no time saving. Now, though, the issues is just a starting point, but the tool will actually do the drafting and redlining for the lawyer as well. So you just jump to the right part of the clause, you just eyeball it. If it looks right, you hit a button and it wordsmiths it in. And I think that wordsmithing, of being able to go word by word in track changes, much like a lawyer would, that just wasn't possible from a machine learning perspective. So the best tools back then, they would just, delete and replace. And our clients would have never accepted that. If we sent a contract marked up like that to our in-house legal clients, they would say, this is ridiculous. Like, we want to minimize red lines. This looks like we changed everything, but in reality, you're just substituting things that are similar enough.
Yeah, we had the same sort of experience with Factor, I guess it's probably the business that we at the time called it contract intelligence. And when we split Axiom up into multiple pieces, there's little bits and pieces of it at what became Factor and what became knowable. But the basic idea when we first started, when we were just experimenting with these ML technologies, we had teams of lawyers doing these like deep contract reviews. They're looking at maybe 10,000 documents, and they're trying to extract 100 standard data points for every document that's in this project. And we were trying to add the ML to their workflow to try to make them faster. And in the early days, this is early days, like this was only like 8 years ago. It was really close to not saving time. It was almost to the point where we were actually just making the project more complicated by applying the machine learning technology, because it would spit out extracted data points, but a human still had to check everything. And maybe the AI could scroll the person to the right page in the document and say, hey, I think I found the answer to this question here. And as we built the right user experience around it, like we went from it's a bolt-on tool to it's just part of the review process, we did get to an efficiency, but we were nowhere close to the kind of efficiency that we start to see is possible today. And I've tried to think about what's fundamentally different. And in my mind, it's just the ability to understand language. So The way I think about and explain these large language models to folks all the time is before we had a thing that could recognize a pattern and try to say, hey, I found this pattern over here. And now we've got a thing that is actually able to, how do I say it? Read and understand in situ. And I don't think we're quite to the point where, they're reasoning the way that humans reason, but they do a pretty good job of stringing facts together and making suggestions and explaining what they did. And I'm just amazed at how people are starting to harness that capability and bring it to life in interesting different ways. And so what you guys have done with DraftPilot, I think, is truly cool. Being able to say, hey, I found this is out of spec with my playbook, and then trying to make a suggestion to bring it back, bring that language into spec without saying, oh, this is out of place, let me just wholesale replace it with something out of my clause library. It's just much more like what a real person or a junior associate would actually do when they're reviewing a contract. And so it feels more natural and in the workflow, like in the moment, like you show it to an attorney and they're not off put by it. They actually find it to be helpful. That's been my experience and our experience, deploying DraftPilot as well. Fundamental change in the technology that I think people are, as they experience it, feel less affronted by than maybe previous generations. So when was the moment you decided this is really a thing? Like, this is fundamentally different and I'm going to go build a company based on this change?
So that must have been nearly 2 years ago. So a year and a half ago that we thought, okay, what we're seeing coming out of OpenAI and then quickly after Anthropic, it is actually, it solves the one bit that I knew needed to be solved for it before it could actually save time. And, anybody does a mean demo, but because we were so familiar with the actual work, when we tested it, I thought it actually got it right. It's like the bit that I would have corrected in the previous tools, it got that right. And there were so many rough edges, and there still are sometimes. So we thought we should design the tool in a way that it surfaces it to the lawyer, and it just makes it super easy for the lawyer to glance at it and look like, yeah, that's how I would do it, and hit apply. I think the other way we could have gone was auto review, which is where a lot of the techies who are not from the space went, that they thought, oh, just send us the agreement, you get a full copy back. And then you get, a real falling asleep at the wheel risk, that it's easy to just not check it at all. And definitely 2 years ago, the tech wasn't there where that would be remotely responsible. And if we look at our clients today, that's not how they want to use it. It's their in-house lawyers. Almost every contract might have 1 or 2 points where judgment is required that can't be captured in a rule. So that's the way I think about it. There's a spectrum of every task the lawyer does. Some is kind of rule-based. We need 30-day payment terms. Let me just fix that. And sometimes it's, well, this is a very big customer of ours, and this is very urgent, and we need to close it by the end of the quarter. What does that mean for where I go on the liability cap? So that's judgment that is harder to capture in a rule. So the ideal tool, in my mind, was one that surfaces everything that the lawyer needs to be able to blast through the rules, but that they can weigh in on the bits that require judgment. And I think if you just remove that ability to exercise judgment in the work, you kind of lose the special sauce that the human lawyer adds.
Oh, wow. You make me think about talking to a customer service chatbot, but maybe we won't go there. I know that Axiom attorneys, when we've trialed and deployed DraftPilot on real work for our clients, Axiom attorneys have said over and over again that they really appreciate that DraftPilot doesn't make changes for them. It suggests changes and keeps them in the driver's seat, right? It allows them to exercise judgment, and that's definitely different than a lot of tools that we took a look at in the market, where they were making the red line direct in the document when they saw the issue, and then sort of putting it on the attorney to, if the red line's totally out of whack, fix it. Versus DraftPilot, you made like a really disciplined decision to draft the change outside of the actual document itself, right? You guys even built this UI on the side panel of Word that has like a copy of redlining, if you will, right? Like you had to invest in that specific UX pattern to make that function. What was the moment when you decided that was like the right UX model? How did you figure that out, or was it just natural from your past experience?
I think it's my experience working with lawyers, and I guess being one myself. I think from a very early point in our careers, we're trained to pick and find flaws. So we'll say, "Hey, that's not quite right," and look at me, I found that, so I've added some value right there. And I think the best lawyers know when to apply that skill, and the worst ones don't, and they apply it indiscriminately. So I felt with this new technology, there's going to be a lot of that because there's also a little bit of a threat in the air. Again, there's lawyers on the spectrum, from lawyers who love to be strategic and really think deeply about the bits where human lawyers can provide extraordinary value. And they're sometimes covered by so much business as usual work, they don't get to do that. Now, those lawyers love tools like this, but on the opposite end of the spectrum, you have a lot of lawyers who don't mind being stuck on the hamster wheel and feel very productive at the end of the day, just going through the non-strategic bits. And obviously for those lawyers, a tool that says, well, we can help you with the rule-based stuff is maybe a little bit less exciting. So I thought, we're going to come under a tremendous amount of scrutiny on every single bit of legal drafting we do. So I thought the best way to surface that is in a non-threatening way where it's not actually in the document. So no accident will happen there because you can spot it in the box and then hit apply. Now, one of the biggest feature requests we still get is apply all, and we still haven't built it. And I think maybe I need to either get over myself and say that the AI is ready to do that. But my worry is that lawyers are very busy people. They get so tempting to just press that button, and then it's in the document. And if it's then not right, unpicking a red line that has just been applied and you don't really know why or in which context, it's just a lot more work than being able to influence it on the way in.
I personally think this is like an ROI conversation for in-house teams. If you've decided that a document's important enough to have a lawyer review it, then you want that lawyer to exercise judgment and running the playbook and providing suggestions to the lawyer. I think that makes a ton of sense. But we do hear from Axiom clients that there's a lot of document types that they have just deferred the judgment or deferred the risk back to the business, right? Hey, for an NDA, it's not worth our time. We're not going to look at it. For a sales agreement below a certain value threshold, we're just not going to look at it. And clients have just asked us, like, is this stuff good enough that I can just have it spit out a red line? Because, hey, that's better than the risk I'm taking today, right? And I think you told me a story about one of your clients who asked you, for the same thing, right? Like, just have a business user send a document to this email address and hand them back a red line. It's dangerous, right? Like, what if the AI goes off the rails? I've used DraftPilot and actually demoed it on the same document with the same playbook, probably at this point hundreds of times. And I have seen DraftPilot give me slightly different versions of its red lines many, many times, right? Same environment, different output, and in some cases, just like patently wrong output. Not often, but sometimes that happens. So for me, I wouldn't advise someone to just have an LLM powered robot go do an automatic play. But hey, maybe it's better than just having no lawyer look at it with no playbook at all, right? I mean, that's going to be a fundamental decision that GCs are going to have to make. And hopefully it's not as bad as, customer service chatbots from your airline of choice. I don't know that either of us has the prediction for what that's going to be in the future, right? I will say my favorite quote about the future of AI prior to last week came from an Axiom attorney, David O'Hara, who I know you know. And his quote was, "I'm not worried about the robots taking my job. I'm really happy they're taking the part in my job I don't really like." I thought that was inspiring and sort of framed a bit of the moment, and also maybe explained how he's not worried because he knows these things just don't exercise judgment, and he does, and that's the value he brings. He's really leaning into his value. But last week, I met an Axiom client in Houston, and he gave me a quote that I think I might like a little bit better. He said, the robots aren't going to take the jobs of lawyers. The lawyers who are using AI are going to take the jobs of lawyers who are not using AI. And I thought, okay, well, if you sum up the anxiety of the moment and you think about the capabilities of the tools, that rings a little bit true, and maybe is a hearkening call for attorneys to, hey, this stuff is finally ready. It's time to embrace the future. And I think tools like yours really make that an approachable, non-scary sort of thing. Like I'll just share this with you. My favorite feature of DraftPilot is the feature that doesn't demo well, which is the light blue highlights on the page, because I think that's how lawyers really review contracts. Like I don't know any attorney who just feels really comfortable with just looking at the issues that the AI spots. Every attorney I know is going to read the document top to bottom. And the thing I love about DraftPilot is that every place in the document as I'm reading that the AI wants to make a change, it just highlights it with light blue. And if I click my cursor there, the AI pops up on the side as like, here's the changes I want to make. It's sort of like a very overeager assistant. And when I show that in demos, it's amazing because it's almost like there's this fear that people watching the demo have. And it just it's like you can see it on their face. It sort of just melts away. And it's like subconscious and light, but I really like that. What made you decide like, oh, I need this light blue highlight? Because for me, like that's the magic feature that made me convinced that an attorney is not going to have, a panic when they use your product.
Yeah, it ties to a bigger theme that I learned a big lesson about the hard way at Lexu, which is even if the tech works, that's necessary but not sufficient to actually get the efficiency gain. You need the lawyers to use it. And whenever I tried to force lawyers to go work somewhere else, like, I know you like reviewing in browser, but why don't we try this? Why don't you you like working in Word, but let's go to the browser and upload it there and figure out this new way of working. Typically, I would check the data and nobody actually used that.
Of course not.
And then I'd be excited about the tool, but then, there's no point. So I thought for DraftPilot to work as a tool, it needs to do both things well. It needs to get it right from a tech perspective, but very importantly, the lawyers need to want to be able to use it. So the closer we can hug the current way that a lawyer reviews a document, the more likely that is. So that's why we thought most lawyers do scroll through a document. They don't want to start in the add-in. The add-in is a new thing. They want to start in the document. So if it can be clear from the Word document itself on every clause, oh, DraftPilot has something to say on this one, they could just click in the contract and then it just appears in the side panel. That would be way easier. So that's why when we built that, we got this real aha moment in the calls that people are like, oh, I now see how I want to use this, and this is good. Because I think a lot of general counsel have been very much burned by buying expensive tools that then sit on the shelf, rightly or wrongly, just because the adoption isn't there.
Oh, that makes a ton of sense. Actually, that blue highlight thing, Daniel, does it run even if you don't have your side panel open, or do I have to jump through the hoop to open DraftPilot on the side first before the highlights will show up?
Yeah, you have to, because we don't put them in the document permanently. So the older solutions would just add, a hard yellow highlight. But then again, as a user, you have to remember to remove those before you send the doc to the other side. Yeah. So again, we don't want to put anything permanently in the document that makes it either apparent to anybody else how you're doing your work. That's nobody's business. So the highlight is this layer on top, and it actually disappears if you close the add-in. So there should be no anxiety that you've left a few highlights in the document before you send it to the other side.
Yeah, that makes a ton of sense. We're just talking about people getting the value, and I guess if a lawyer opens a document and forgets to open DraftPilot, there's a missed opportunity to add value. And then I don't know. We certainly don't want Clippy popping out and saying, "Hi, I see you're writing a letter." So I get the trade-off there, but I think you've done something magical with that light blue highlight, and it's great that it's just based in fundamental understanding of what lawyers really do. So why don't we maybe talk about some features your product doesn't have? Because I mean, we've talked about this, and I know there's reasons. And maybe let's just hit the hard ones, right? Like DraftPilot doesn't learn from every time you negotiate a document. It doesn't just magically get better every time you negotiate an NDA. You don't have clause libraries. Playbooks are just plain language. You don't need to train it on a 1,000 copies of what you've done before. Like you're taking a fundamental stance that historical behavior is not what is actually fundamentally important in this process. And then maybe you even don't, maybe you've added this, but like, at least in the version that I'm familiar with, you don't have fallbacks either, right? It's just pointing out problems and suggesting changes to get them into alignment with the playbook. These are features that many of your competitors and many traditional tools that have tried this without LLMs all have said for years are super important. They're critical to the negotiation process. And if you're not, I don't know, well maintaining your document repository to prepare for the AI future, then you're going to miss the boat. And you're just saying like, you don't need any of this stuff. And that's all, that fundamental wisdom is a lie. Or maybe it's not a lie. You just don't think it has the ROI. So tell us about why.
Yeah. Big question, CJ. I do have very fundamental views on this. So there's two ways to build a product. One is to try to create a product that can cater to every single edge case and do every single thing to 100%. Now, theoretically, if it's truly 100% and every single edge case you can imagine, the implementation time is going to be 2 years, because you're going to have to uncover everything that has ever happened over the last 20 years in that legal team and figure out a way to document it. And then you need an AI that can parse all of that and then apply it in real life. So the
check its work.
And then, yeah, exactly. So the complexity of a product like that is extreme. So we shouldn't want to go 100% and cater for every edge case. So what is the ideal point? If that's the spectrum, where should we sit? So I thought the place we should sit is that it's very likely to be adopted, because using a tool like DraftPilot is a lot quicker. And if you don't use a tool like this, then you're missing out. So even if we built that extreme version that caters for every edge case, and if it's not used, then it would have been all pointless. So then I thought, well, what is required for modern day AI, so the most recent LLMs, to actually make really good, solid red lines? And it turns out that offering it 50 versions of what it has done, what the lawyers have done in the past, it does not increase quality. And in fact, as a company, you may not want to stand behind those 50 examples, because those probably happen in a very unstructured environment where you had 10 lawyers with 10 different risk tolerances who are all just doing what they thought was best. And there probably isn't ideal, but the examples may not be it. So actually, it gives you a very false sense of comfort to train an AI on a huge corpus of past negotiations. So we thought, let's make use of this opportunity to just have very transparent, clear positions of what we want the AI to do. And typically, if you have a template contract on your own paper, that might be the best representative, because at least that is being reviewed all the time to judge whether the risk tolerance is about right. So we allow you to upload that, and the tool will turn that into a playbook. But to see 40 examples, we just didn't see any quality uplift from that. And in fact, it makes it harder to upgrade the LLM. So some of the tools that went that way and tried to do deep training in the middle of the AI based on historic positions, a new LLM drops and they can't just switch. And we've seen huge improvements in quality from a new LLM dropping. So it's a bit risky to try to out-engineer OpenAI on these things. So it's been really nice being lightweight in that respect.
Oh, wow. So your fundamental principle actually turns out to be a technical advantage as well, uh, if you will.
Yeah, yeah, it has been. And I'd be lying if I said that that was so apparent to me when we
Oh no,
started
come on,
out.
man. Just take the bow. You're a genius.
Yeah, so we really got lucky in that respect, but now it's like why we changed the approach because every new model that comes out, it seems to get better at better. And you can very quickly give feedback by just updating the playbook. So if you don't like what the tool did, just add one line to the playbook, and that's way quicker to be implemented by the AI than trying to have a learning and feedback loop. I think that's all kind of machine learning thinking where you need like 50 to 100 examples to teach something and you're aggregating that and so on. And extra benefit from an IT security standpoint, it's also a lot safer. Most in-house legal teams, they don't love the idea of their contract negotiation history being hoovered up by an AI somewhere.
Oh yeah, they totally don't. I mean, we don't either as a consumer. In fact, it gives Axiom a lot of comfort and our clients a lot of comfort that DraftPilot literally remembers nothing about the contracts that it has negotiated for the client. And I in my talk track, when I talk to clients about this, and I just honest with them. I'm like, look, seeing another example from your document past is just not is the tiniest drop of water in the ocean compared to what these LLMs have been trained on. It's not going to make any difference. And so this fear that these companies are going to train their models and somehow make them so much better from your usage is just sort of crazy, right? And I don't really understand what series of missteps occurred in the very early days of LLM rollout that caused everyone to be terrified of this future where the AIs were all just going to learn from our interactions with them and hoover up all of our proprietary information. I guess it's, hey, they trained them on the internet, so they're also going to train them on my conversation. But it's good to know that it's just not necessary. So you talked about training on the historicals, which makes a ton of sense, and how the playbook functions. But what about fallbacks, Daniel? That's a feature I know that clients love. They like to, when they build playbooks, they like to talk about fallback positions. And you talked a little earlier in our chat today about attorneys exercising judgment and know where to give. How do you think about fallbacks? And is there anything from your Lexu days that's informed that line of thinking for you?
Yeah, I think fallbacks and defining them up front is usually important. If I looked at the data set we had at Lexu of what would drive not just time spent on the markup, but especially time to close, it was typically the number of negotiation rounds. So very simply, if it went back and forth 6 times, it would take twice as long as if it went back and forth 3 times. And that's because every time the contract is sent to the other side, it usually sits somewhere for a week. And then somebody else has to look at it, and then it's escalated and so on. So the thing that would correlate whether it was 3 negotiation rounds or 6, it's which positions do you take? So do you push for something that's fair or not? And often because we were an outsourced provider, the client didn't really have an incentive to have us push for reasonable positions, or at least they thought they didn't. So they said, oh, we've agreed this 10 years ago, just use these positions in this playbook. And we would see, oh my God, this is taking us so much longer. So we started to price that in. So we said, look, if your positions are on market, and that's fine, but we're going to have to charge you twice as much because it's going to be twice as much work. And then all of a sudden, they were listening a bit. Even then, though, it would help us show some data on where they ultimately had to end up anyway, so to see that they weren't actually losing that much by making their positions a bit more reasonable. So within the tool, it is very important that we have that. So currently you can define your fallbacks within the tool. It's just that the AI, you have to decide, do you want the AI to focus on your preferred positions or your fallbacks? And currently we allow the AI to focus on one position at a time. So what we're building now, and it should be live in 6 weeks, is the ability to tell the AI, hey, this is my first review. of this third-party paper, or no, we're somewhere midway in the negotiations, and here's a range of fallbacks, and the AI will just offer drafting suggestions for each and every one. So that as a user, you can exercise judgment and decide which one is appropriate in this case, but it will have surfaced all of them for you. And similarly, there may be something that you haven't had a fallback for yet. There's an infinite range of stuff that might pop out of a negotiation. So in that case, the AI will proactively come up with, this seems fair, or here are some ways to think about that.
Right. I for what it's worth, I think you picked the right starting point, because it's easy to figure out where you would like to end up on your own paper. It's easy to ingest your own template. I actually think it's a lot harder intellectually to define what your fallbacks are and what your rule set is around using them. And I don't know, at least in my personal experience negotiating supplier contracts, I've found that the place we end up tends to never be exactly one of the pre-contemplated positions. So it's never really hurt my feelings that DraftPilot didn't initially have this like robust built-in support for fallbacks. And I'm glad you're getting there and you're building better support for it, because I've heard that request from clients and from lawyers who are using it, that they want fallbacks. But then I ask them, what are they? Are you ready for it? And oftentimes the answer is, oh, well, we probably do need to figure that out. Because I think everybody knows that they feel they've been trained that they should have playbooks. And they've been told playbooks are what good looks like. And playbooks are these big, complicated spreadsheets that are based off of your template. And they have all of these rules, and they have all of these fallbacks, and they have suggested desired clause language behind them. And they take months or years to put together, and they're hard to maintain. But that's what we've been told. Like, we've been conditioned to believe that is what good looks like, so much that we have anxiety when we don't actually have it, but we know that, oh, okay, well, this is what good practice looks like. And so I can't select a tool that doesn't have all of the features built in for what good looks like. And yet 90% of what we do, or what attorneys do every day, is living outside of that perfectly playbooked, manicured world. And I don't know why we are holding products to the standard that they should support this. They should support all of the features that we have been told to believe we need. When in reality, that's just usually not what we encounter on the ground. And I think that's what has made DraftPilot just so simple to adopt. And I think that's why when we show it to attorneys and we show it to clients here at Axiom, I mean, people just naturally, they look at it and they say, oh yeah, that would be helpful for us if we do any significant amount of regular negotiation of the same types of documents on repeat. So that's pretty great. I know we spent a lot of time talking here today, Daniel. So maybe if you could just give the listeners, what is your one piece of wisdom? What is the thing that you would like folks to take away that is your perspective about the future of AI and how it's going to affect the legal practice? Your moment of zen, if you will, Daniel.
So the way I view it is, on the one hand, it's mind-blowing and none of us could believe that it can do what it can do. On the other hand, the reality on the ground is that, not that much has changed. For the last 10 years, we've been working with legal ops, and legal ops' goal was to use people, process, and technology to get to great legal outcomes. And AI has given us a really spicy ingredient to throw into that pot, and it's enabled a lot of progress that was really hard to get before, to put those three together. At the same time, businesses are still relying on their legal teams to help them guide on risk. It's just that those lawyers end up with a really powerful tool in their pocket. But it's a really exciting time, I think, because it was Richard Susskind. I think he said it in 2013 that there's this big more for less challenge in how legal teams are expected to do more and more and more with fewer resources. I think Axiom was and is one of the amazing new puzzle pieces that came out when you were founded that wasn't there before. You don't have to send everything to a law firm or keep it in-house. You can solve it this way. And I think now we have another powerful piece, which is this AI technology. But I don't see legal teams as a whole being deleted. I don't see any corporate actually thinking or suggesting that, yet that's what I read every day in the newspaper.
Yeah, we don't think it. Axiom is a shock absorber. That's our current way of describing what we do with our flexible talent solutions. And we just look at AI as making the spring a lot stronger than it was before this generation of tools existed. But obviously, we still see a very bright future with very bright attorneys exercising judgment day in and day out, and we don't see the legal industry shrinking. We just see this as an accelerant. And quite frankly, and you saw in our pilot learnings and studies of applying DraftPilot to work, we just see it as a way of increasing the quality of output, right? Like that was probably the most amazing thing to me in our pilot methodology findings report that we put out, that lawyers would say, hey, yeah, it did make me faster. It made my work better too. And, when we dug into why, they said consistently, it felt like the AI was a junior associate taking first pass. And that was just the light bulb moment for me. I'm like, okay, this is just like vegetables. Like we all know that having a junior person working under your direction take first pass will accelerate a senior person at producing a result, but it'll also almost always make their work better. Because the junior person is going to have unique ideas and thoughts that they bring to the table. It's just two heads are better than one sort of situation. That's where I feel like we're at with AI. And that's why I think, it's why I like that quote, that it's not the attorneys, it's not the robots that are going to take your job. It's the attorneys who are using AI who are going to take the job from attorneys who aren't making that adoption. And I think it's just going to show in their work product quality. And that's the standard. How good's your work? Well, Thank you for joining us today, Daniel. Really appreciate you coming on the show and being one of our early guinea pigs. Thank you for your time. And thanks everybody for listening. We'll be back with more of these Axiom AI legal tech podcasts in the coming weeks.
Thanks, CJ.
Thanks, Daniel.